Commissioner Adara? We're taking a roll. Commissioner Kasher?
Here.
Commissioner Wasserman?
Here.
Commissioner Nguyen?
Here.
Chair Remke?
Here. Okay, good morning. We don't have any special announcements, so I will just start by asking if there's any public comment for any item that is not on the agenda today. Okay, seeing none, we'll jump right in then. Item 2 is approval of the October 2015 committee meetings.
Yes, have a public comment. Phil, just one.
Oh, that was so close.
It really was. I'm sorry, Madam Chair.
All right, go ahead. Public comment.
Sorry to catch you by surprise. I just got off the elevator. Philip Ong on behalf of California Forward. Happy to take a couple minutes of your time if you'd spare it, Madam Chair. First off, we want to welcome Commissioner Darrow to the commission. We look forward to working with her in her new capacity.
Thank you very much.
You're welcome. And then also we'd like to take this time to present a document to the commission that we finished a couple months back, but haven't had a chance to present to you until today. So I'll give that to Ms. Peth right now. This document we're calling our recommendations review. It's really kind of a meta study of all of the recommendations that have been made through about 7 or 8 studies, bipartisan commissions, task forces, advisory committees, and such that have been formed over the last 2 decades. California Forward is part of a lot of these task forces and discussions, and we thought, well, let's not recreate work and recreate the wheel. So let's go through and see what has already been recommended. So we put together this document. What we found were 150 recommendations made over 2 decades. Some of them were repetitive. Most of them were unique. They range from very specific recommendations to very broad, and most of them have been enacted as well, either through regulation or statute. There's still lots of room for improvement, as I think all the commissioners know. And so we just wanted to make sure that you had that document to help you and your work as commissioners. You know what has also been put together by task forces. And also we'd like to thank the commission for lending their staff to this project, especially Erin Peth and Hyla Wagner and Linda Cassidy when she was here, to help us put this together so we can figure out what was actually enacted through regulation and through statute. So I think my time's up. Thank you, Madam Chair.
No, thank you. I have a couple questions. Number one, can you send this to us electronically or to John Kim so we can post it?
Absolutely.
Yes, so we'll just post it so everyone who doesn't have a copy can get a copy. What these mean, the categories on the far right.
The categories.
X, check, yellow.
Yes, those are really visual. That's a visual guide to help you figure out. It coincides with the status, which is whether or not it's been enacted, not enacted, in progress.
But is there a place where the symbols are defined?
No.
The status column is
The status column.
due to the
right.
towards the left.
Oh,
and the
so
right-hand
I
Yes.
see. The X is just consistent with
Yes.
not enacted. I gotcha.
I understand there probably would. There probably needs to be some clarification there. Also, there's a column labeled source, which has a page number for where in the report or recommendation document that source comes from. So if you were to go to, say, the FPPC or Mr. Schnurr's task force, you would go to page whatever the source was to figure out exactly where it is. So
Okay. Well, this is very comprehensive, and thank you for all your work on it.
thank you for your help.
Okay. Is there any other public comment? Is anyone coming off the elevator right now? No. Okay. So back to approval of the October 2015 committee meeting minutes. Are there any comments or corrections from the commissioners? Okay. Is there a motion?
I move approval of the October 2015 commission hearing minutes.
Second. Commissioner Adara?
Yes.
Commissioner Kasher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Nguyen?
Yes.
Chair Remke?
Yes.
This motion is approved.
Okay, moving to the proposed consent calendar items 3 through 73. We have Galena West. Chief of Enforcement. So to start, would the commissioners like to take any items off consent?
Yes, I just have yes, number 4.
Okay. Any others? Okay. Questions or comments from the commissioners for Ms. West? Okay. Any public comment for the items on consent? Okay, seeing none, is there a motion?
I'll move approval of the consent calendar, items 3 through 73 minus item 4.
Second. Commissioner Darrow,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes,
Chair Rumkey.
Yes.
This motion passes.
Thank you. And then we have item 4. Any questions or comments on item 4?
Yes. So the comparison that was made for the total proposed penalty was the firefighters case. And I'm just wondering how much was not disclosed by the firefighters case and over how many years, if we have that information, because that one was the full penalty amount, and this one is less. And this one is $90,000 over, I think, 3 to 4 years. And I have nothing to compare with to see which one is if this was more egregious than the firefighter comparison. Did I miss it? I'm sorry if I missed it.
Okay, sorry, go ahead.
That's okay. Galena West, Chief of Enforcement. For the firefighters, actually, the violation amount was the same, $3,500. So
Okay, then maybe that's my question. Is this more egregious than the firefighters case, meriting a higher penalty?
I don't know the exact numbers on the firefighters case, but using it as a comp, it would have been a comparable amount. But since this violation was about the naming of the committee as opposed to their expenditures, that's why it wouldn't have been included in the comp, because this charge itself was more about how you identify yourself as a committee as opposed to how much you spend. So that's something I can look into for you. But off the top of my head, I don't know the amount that the firefighters spent.
Okay, no, I understand the distinction. Thank you.
Okay, any other questions or comments, commissioners? Any public comment? Okay, I move to approve item 4.
Second.
Commissioner Darrow,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
yes,
Chair Rumkey.
Yes.
This motion passes.
Okay, and Ms. West, just while we have you here, and because there's a significant number of the $50 fee cases obviously on the agenda again, I thought maybe it'd be a good time for you just to give us a quick update on that. I know it's in your report, but just so we know the progress we're making, I think the goal was to get through the 2013 cases. Is that by the end of this year? Beginning of next? What was that? What was our goal?
Certainly. I think my report's in my addendum binder since my binder wasn't big enough. But yes, it's actually a great time to give you an update because we're down to 114 of the 2013 referral. If you remember, the referral came in at 2,460 cases that were referred to us from the Secretary of State's office, and we're down to 114 that are still being processed as streamline and warning letters and determining and reaching out to those committees and finding them. So it's a significant movement that we've made. And then also with, if you remember back, we adopted the new administrative termination regulations, and they take 45 days once you've noticed the committees. And so we're working with all of those committees. And if you see those numbers, slated for termination is over 1,095 committees. And so those are all committees that will no longer be marked as active committees for this coming election year. So when you do searches for active committees to get information, those will all be off the records by the time the June 2016 election comes up. So we're very proud of the progress that's been made. We just received the 2014 referral, which is substantially smaller because of all the cleanup that we've made. And we'll have those numbers to present to you next month.
I just wanted to say that Galena and her staff deserve a lot of accolades for the amount of work that has to go into this kind of a project. And it is important work. It can be minute and overwhelming at times, but we as a commission have spent a lot of time and resources in it, and it's resulting in, as Galena said, just more efficiencies for the future, but also revenue for the state, and obviously a strict enforcement of a requirement that is in the act. So she deserves a lot of credit, and as well as her staff.
Can I make a comment?
Yes, please.
Yeah, congratulations, Galena, and thanks very much. I know this feels like a slog at times, but it is important to just kind of get everybody on track. When I was going through the manual that we're going to adopt later, I didn't see that this provision was well highlighted. It seems like it's a common mistake that candidates make, once their campaign is over, that they forget to close their, or hold their, accounts open and don't file anyway. I was just hoping that we would kind of look for that and make sure that, candidates are well informed of this provision so they don't get, just caught up in it.
Right. I mean, we can definitely try to highlight that better, but I also think through this effort, filing officers, so a lot of these committees, or majority of them are local committees. I think this is sort of educating everyone on the importance of terminating the committees when appropriate and keeping our records updated, both on the state level at the Secretary of State's office and at the local level. So I think we can definitely highlight it further, but I also think this is helping just educate, the public officials, the filing officers, as well as the candidates.
If I could just make a quick comment. So, having just gone through like 50 of them and then going right into reading the manual, I was kind of watching for it, with maybe a keener eye than I normally would have. So if someone's running for office for the very first time and they pick up the manual, I didn't see it highlighted well enough, just, in view of the fact that so many people get caught in it. So
Did you check out our candidate toolkit online?
I don't think I did. And if it's there, I mean, that's great. But, I'm just, I was just hypersensitive to it, having just read through how many people, really, it probably is inadvertent in most of the cases. And, the campaign manual is so complete. I just wanted to make sure that we, included that one
Absolutely.
provision.
And we'll definitely relook at that.
Okay, any other questions or comments for Galena on her report while she's here? And she's going to stay here because then we'll move to item 74, which is adoption of amendments to regulations 18360 and 18362. And Suki Brar is going to present.
Good morning, Chair. Good morning, Chair Remke and Commissioners. Suki Brar, Senior Commission Counsel with the Legal Division. I'm here to present proposed amendments to Regulations 18360 and 18362. The purpose of these proposed amendments include staff identified ways to improve enforcement procedures for notification to respondents and complainants in the enforcement process, and to make them more clear and easier to understand for the public and more efficient. And also, we've identified the need for an established media and public records request policy when it comes to enforcement records. And so for those reasons, that is why we are presenting these regulations today. I wanted to note that we have made some changes to the noticed version of the regulations. These were posted on the website late yesterday afternoon and have been provided to the commissioners as far as I know. And also we have provided copies here in the meeting room today. And
If anyone doesn't have a copy, we do have copies that can be passed out if you want to raise your hand. If you don't have the latest version, which says 11/18/15 on the bottom left corner.
And the changes are highlighted in the draft. We did a track changes version from the notice version to today's version. And I just wanted to summarize what those changes were, and they were in light of comments provided by the regulated community. And thank you for those who provided comments on these regulations. We've changed the release, the waiting period for the release of a copy of a sworn complaint or confirmation of a commission-initiated complaint and copy of the notice for that from 2 to 5 days. And we've made more clear the language regarding what information a complainant should provide in their complaint when they submit that to the commission. And also made clear that Public Records Act requests for enforcement records should specifically state the documents that people are requesting, but they don't necessarily have to be in writing, though we obviously would prefer them to be in writing. So that's just a summary of the changes from the last draft to today's draft. And so with that, staff recommends recommendation or adoption of these recommendations. Thank you.
Thank you. I would just like to say, I think these regulations are great. Since I started only 18 months ago and I was looking at our enforcement regulation and I said, this isn't how we do it. So this is really to conform with what the practice actually is, which I think is important that we have that down. And so people know the practice. I think it's about due process and fairness. So everyone understands it. Everyone is treated the same. So I think these are great improvements and I appreciate the work from staff. Any other questions from the commissioners?
I have all sorts of questions, and partly because I'm new, so bear with me, and some of this may require some clarification only. But so what I did is I looked at, okay, here's what the current regulation says, here's what you're proposing, and I'm trying to understand the reasoning of going from where we are to what we're proposing. And I appreciate that the current is not really how we're doing it. Okay, fair enough. So you'll just educate me as to the process. But so what I saw, as I want to focus on the sworn complaint. So right now the regulation says that the letter goes to the subjects of the complaint within 3 business days, right? And it has a copy of the complaint and then information that they can respond before the 14-day letter. Mm-hmm. The proposed regulation does the same, except that it says we don't have to send a copy of the complaint, right? We don't even have to notify the subjects of the complaint. Am I understanding that correctly? If the disclosure would jeopardize the investigation?
And Ms. West is here to answer current practices as
Okay.
well and
Sure.
explanations and reasonings behind what enforcement does. So
Sure. Okay.
Well, the reason that it seems so apparently different is because we tried to be very clear that that is what the current practice is. The current
Okay.
regulation also allows us to not disclose, but it only says it one time, and it's not in your face as, hey, listen, this is a possibility that this won't happen. So what we did with Suki's help was we put it to where it's very prevalent in the regulations, to where you can see, okay, there are going to be circumstances where even in a sworn complaint that we're not going to let anybody know what's going on because the allegation is such that we can't.
So where in the current regulation does it say that? Because I think it says it with respect to the 14-day letter, not the initial notice.
I believe that's in the 14-day letter section in D3,
Right.
and then around confidential informants in E, and then it's also in F3, which is F3. So it's in several different places in the existing reg that covers sworn and 14-day, but in the proposed regulation, we just made it more prevalent to where you can see that. But basically, it's the investigative process. We use it beyond the regulation of if it's going to inhibit the investigative process, then that is when we withhold the information. So we use it as the due process concerns, the CPR concerns of the balancing test, and then also with prosecutorial discretion. So we use those 3 things in combination in order to read with the existing language of the regulation. And that's why we went for clarity in the proposed regulation.
So if the other thing that I noticed was that under the proposed regulations, the commission will confirm receipt of a complaint to the press at any time. So is that then creating a situation where the press will have, and first of all, I don't know what would be confirmed, right? So let's answer that. What would be confirmed?
Generally, what will happen is a press complaint or a press inquiry will come in. Do you have a complaint against John Smith? And we will say, we've received a complaint, it's under review. And that's the information we provide.
Okay.
Just to clarify, but they wouldn't provide that either if you've already determined you're not sending out the complaint
Right.
to the subject of the
Right.
complaint.
Under the
Yes.
no
If there's no
action.
notice,
Yeah.
then there's no confirmation either. True.
So there is a chance that that there's a complaint against John Smith that John Smith will not even know about, but that the press will know about.
That's what I was just saying. If once they decide not to tell John Smith, they won't tell the press either.
Right.
It's the whole thing
Oh.
is confidential because it would impact the investigation.
Okay. So as I read this,
But you are correct that we confirm that we have received a complaint immediately. So there could be a lag time from the time that John Smith gets a copy of the complaint to the time that we immediately say, yes, we have a complaint and it's under review. What we don't do in order to protect John Smith is we don't give out a copy of that complaint
Right.
until after 5 calendar days have passed. So he has time to get it, assimilate the information, and decide what his response to the press would be. So the reason for that is because so many sworn complainants provide the documents to the press at the same time they provide them to us. And so it was decided long ago that it was easier to confirm and more accurate to just confirm that we have it and it's under review, which doesn't mean we're investigating and it doesn't mean that anything has been opened, but it just allows the press officer to be able to have a more honest discussion and say, yes, we have it. So that the complainant doesn't call us after the press runs the story saying the FBPC doesn't confirm they have my complaint and say, do you have my complaint? This gets rid of that game of telephone to where all we're doing is saying, yes, we received it. The complainant did send it in. It did reach us. And that's the only confirmation that we're giving.
so there is a risk that John Smith is going to find out through the press.
Find out a complaint has been filed.
Yeah.
Yes.
Okay.
But not what the contents of the complaint are. Not even the press will know that unless the
Right,
complainant has
right.
contacted them. Yeah.
Okay. I think if I were John Smith, I would have a concern about that.
Mhm.
Honestly,
Honestly, that is the catch-22 of the press policy
Right.
because we've been in both realms over the years. We used to have radio silence to where we didn't even confirm an investigation was ongoing. We confirmed nothing. We provided nothing. We basically had no press duties because there was no communication with the press in any way. And so a lot of the common cause types organizations say, hey, listen, you should be doing the opposite. You should be telling us everything. You're a government agency. And then the press policy went 180 to under a certain chair, there was a policy of posting every complaint on our website as it came in. So with instantly when it came in, it was scanned and put onto the website. You could click on it, read the complaint, and no notice requirement was there at all for the person to have any time to respond to it or even have acknowledgement of receipt. So this is a swinging pendulum, and this is to just strike a balance between getting the information out to where everyone has the information that they need, but then also not providing the documents so that you can't necessarily get blindsided with the information. So we're just trying to protect you from having the specifics and getting specific questions, but having an allegation of, hey, I heard there's a complaint filed against you. You're much easier to be able to say, oh, okay, I'll look into it and I'll get back to you, as opposed to here's a complaint against you. I have it right in front of you and right in front of me, and it says this, this, and this. So we want to protect them from the specific questions that it would be unfair for them to not be able to answer, but yet still strike a balance of we can confirm that we received something. So that's kind of what we're trying to do.
Can I ask you a question how enforcement would handle, for example, let's say it plays out in the most perhaps troubling way where the press gets a hold of it, they call to confirm that we received it. We said, yes, we received it. They run a story that there is a complaint pending. That official or their representative calls enforcement. Would you guys turn over a copy of the complaint sooner than
To
to
who?
the subject of the complaint?
It would
they're
already be in the
calling-
mail, and then we would just send it to them electronically if that's
Right,
what
so
they
I'm saying
needed.
they can get it as soon as they
Yeah.
hear, if they hear for the first time in the press.
Of course, yeah.
Yeah.
We cooperate with complainants and respondents to try to get as much information from all of them as possible in the most timely manner.
Okay, and then going back to the statement that if you have made a decision that you're not going to provide the information to the subjects
Mhm.
because it would jeopardize the investigation, then then you're not even going to confirm the receipt of a complaint to the press?
No.
I think it would be good to make that clear, because as I'm reading the regulation, it's clear that you won't disclose to the press the action that the Enforcement Division intends to take, which to me is the 14-day letter,
Okay.
not the complaint itself. And correct me if I'm wrong. But when it talks about the commission may confirm receiving a sworn complaint, this is G1, receiving a sworn complaint at any time, but will not provide a copy of the complaint until now 5 calendar days after the complaint is sent to all persons the complaint alleges. So maybe might be a good place to clarify, so that you don't then have the press coming after you saying, you're supposed to give it to us. There's nothing here that says you won't.
We could do that. We have that in the subdivision 4 protected information on the same page. Where- Right. So we did a G4, so that way we didn't write it in every section, but we could write it in every section because since we have sworn, commission initiated, and referrals in separate sections, we did it as a G4 in order to encompass those 3 sections. But if the commission would feel more comfortable with it in the 3 sections, we could.
I'd prefer not to repeat it 3 times, but see, because that's why it's a catch-all.
If it's unclear, we could put it as 1 and then 2, 3, 4 for the sworn, the commission initiated, and the referrals.
But why
So-
is 4, I guess I
Yeah,
would ask.
Okay, I took 4 as withhold the ability to withhold the document, information about the investigation, et cetera, not the complaint
It says the
itself, but okay.
existence of an investigation. I guess we could say the existence of an investigation or complaint.
Yeah,
Okay.
maybe that's where to do it. Just so that it's super clear, because I think that I worry about the press coming in and saying, but look at G1.
I worry about that every day.
Right. Yeah.
Okay, so we'd add or the existence of a complaint or an investigation, right?
Yes.
Okay,
Or investigation or complaint, either way.
Yeah.
Mhm.
okay. Any other questions?
I just another comment. I do agree with one of the letters that addresses the issue of what do you mean by confidential? You're withholding anything that's privileged or confidential. That kind of struck me as well when I was reading it. I know what privileged is, right? There's all sorts of rules on that, but what is confidential? And I agree with the letter. Who determines that, and how is that going to be addressed?
I think we use the term confidential in order to try to give the catch-all of all the situations, because over the years, getting 1,800 complaints a year, so many different situations come up that we never thought we would have exposure to, different privileges and things that aren't exactly a privilege, but it's confidential information that has been provided to us. We've had people illegally obtain documents. So things that don't strictly fall under privilege, but things that we would never release, and we usually return to the people, because especially we've had illegally obtained IRS forms and things like that. So we try to use terms that encompass situations that you wouldn't think about happening every day, but give us the wiggle room to not have to be required to release those, because we would never want to compound anything. And so it's almost like you're trying to come up with legally valid terms that give you that wiggle room. So we came up with confidential because we used to use confidential informant and confidential documents and to similarly protect people who provide us information who don't want to be identified, because the words anonymous and confidential had all been used interchangeably. So that's why it's there, and it's generally used in only very specific circumstances in order to protect people's identities or personal documents that have been provided to us.
So, okay, so I understand the confidential. Would the term private also, I mean, there's constitutional privacy rights, right? That would prevent you from disclosing all sorts of information, tax returns, social security numbers, I mean, all sorts of stuff. I just wonder if, at first I thought that's what you meant. And I was going to suggest that maybe that's the term to use. I understand the broader term, but I think it would be helpful to the agency to include privacy as part of what it will withhold, because I think it'll be easier to explain on
You
some
mean
of those.
instead of
true.
confidential?
No.
In
Add.
In
addition,
addition,
Yeah.
privileged,
I think that's-
private, or confidential?
I think that's a smart suggestion because we also look to the Information Privacy Act and
Right.
we apply that when we respond to CPRA requests. So that would be a good addition. Let's see where we would. Do you know where we put that?
Yeah, G4, line 19. Anything else?
That's it. I'm turning off my mic. Thank you very much.
Okay, Commissioner Wasserman?
Returning to the confirming of investigations, could you run once again what the difference is in when the commission may confirm a sworn complaint versus a commission-initiated investigation, and why?
I can, so right now, with the proposed regulations for a sworn complaint, we provide a copy of the complaint to the subject of the complaint within 3 days of when we get it. Then 5 days after sending that, we send copies of the complaint to the media or public if requested. And we can confirm receipt of the complaint at any time, obviously, unless we're withholding that information. So that's all for sworn complaints. For commission-initiated investigations, these are often investigations where nobody has any idea that we're doing that. We provide a letter of inquiry to notice to subjects of the investigation. And 5 days after that notice to the subjects is sent, we'll provide copies of a complaint or confirm that there is an investigation. So we wait 5 days for both of those when there's a commission-initiated investigation going on.
Right. So the sworn complaint can get confirmation immediately,
Yes.
but the unsworn or commission-initiated doesn't get confirmation if the press calls until after the letter of inquiry is sent.
Right.
And the reason for the difference is probably my follow-up question.
I'll take that.
Sure.
Galena West, for those on the phone, I know Suki and I sound identical, but the reason for it is when you get a sworn complaint, it's signed under penalty of perjury, and it's a public document. It says on its face it's a public document, and Aaron just told me I keep saying CPRA. The Public Records Act, it says right on the face of the document that it is a public document signed under penalty of perjury, and so it is given a certain amount of weight by the statute, whereas a commission-initiated investigation can be based on anything. So we want to be able to give people some notice by a letter of inquiry in order to give them time to respond, because it can be based on a nugget of information or a newspaper article. And if we confirmed all of those that we have them before we notice anybody else, you have no way of knowing that, because with a letter of inquiry is our way of telling you, hey, we're looking into this. Can you give us an explanation? It's more of a friendly process. Whereas with a sworn complaint, you have a way of knowing that it's a public document. We're sending it to you. We're giving you notice. And it's something that's been out there, and it's usually provided to the press. So we treat them differently because commission initiated can be just a newspaper article that we've decided to look into. And so we feel like giving you that 5 days where it's just coming out of left field, then that gives it a little more level playing field.
Can I add, though? I mean, to me, the distinction is until you send an inquiry letter or the notice itself, it really is nothing. It's
Right.
you guys looking into something. It can be an informal investigation. It cannot even really be an investigation until you have sufficient evidence to move to that stage of an inquiry or a notice.
Right.
So I think confirming that, yeah, someone forwarded us an email, we may get to that, but it doesn't look sufficient,
Right.
isn't really confirming
It's me
anything
trying to figure out where the jurisdiction is.
yeah, until you've looked at whatever you got that tipped you on this to enough that you'll even at least send an inquiry letter or a
Right.
notice.
Well, because the commission initiated section covers a whole broad range of the way investigations are initiated. Sometimes they are simply things that, in the newspaper we see something about something that falls perhaps under in re Siegel or whatnot. Or it could be someone who just really doesn't know how to do a sworn complaint, or they leave an anonymous complaint or something like that.
Or they're
Or they
in
do,
prison.
pardon me?
Or they're in prison.
Okay. Well, as you said, you see all sorts of things. Or it could be someone who has submitted actually something in writing or a packet, just failed to comply with the procedural requirements for it to be a sworn complaint. So those items also fall under this category because they lack the verification aspect. And I just wanted to think about that for a second, because in a sense, those are the gray line, the gray area, because they become documents, in possession of the public entity, and they are there, but they certainly don't rise to the level of having started the complaint process until we've evaluated them and done our letter of inquiry, or the complaining party has resubmitted them as a sworn complaint. So to get on the other track. But I see what you're saying is that this is an added layer because of the sort of nebulous nature of things, above what you see would be the floor, as opposed to going the other direction, saying that the sworn complaint gets less. You're saying that this is where we start out and then we add more time, as opposed to one getting less. It's just a question of perspective on how you're approaching the balancing process. And because I wonder, about, as you say, it's shifted over the years about where we put the balancing there. About in the case of like a civil action, right? It gets filed, it's in the court record, it'll be there and available, and various entities are there every day mining away so they can get the scoop and call and ambush someone for comment. And then the criminal side's a totally different world, and then we have our sort of civil enforcement world in this sort of the borderline. So anyway, thank you for the explanation.
Commissioner Wynn?
Thanks so much, Galena and Suki, for this. So balancing, I think, is the key word. I heard Member Wasserman using it a lot, and I know that is what we're in. So part of the regulation that we are repealing has to do with the sworn complaint, that it has to be in writing. So now we have a new sworn complaint. So do people phone that in? I mean, so, there is some specificity required, but we're no longer requiring a sworn complaint. I mean, a written document with the required information. So can people phone in this information?
No, because it still has to be signed under
Okay.
penalty of perjury. I think that the wiggle room you might be identifying is that with our new website, we're hoping to have a smart complaint form,
Okay.
to where that complaint form, you can actually put in the little code. Hopefully it's not bad letters, and you put it in and you confirm that that's your electronic signature signed under penalty of perjury.
Not
So-
hopefully that's going to happen with our new
So
case
is there
management
such-
system.
I've heard
Is
it will
there-
happen.
Is there such thing as an anonymous complaint?
There is. It would never be a sworn complaint, but anonymous complaints are commission initiated. What we
commission
try to do is
initiated,
just
okay.
take the language of the statute and only use those two categories to get rid of the confusion of anonymous versus confidential versus all of the other
Okay.
things. So we treat them all with the same practices and rules.
Thank you. Okay, that answers a lot of my question. But I do have a question. It has to do with mostly with section 18362. And that is, when you timing is so critical in these cases. For the most part, it's usually in the middle of a campaign. Someone phones in or types in a complaint alleging something, you know, and then the FPPC is in the position of disclosing, yes, there has been a complaint. So I don't have a problem with that. I totally agree with full disclosure. But the thing that troubles me a little bit is that once we do a complete investigation and find out there is no merit to the complaint, and the other side, the respondent has cooperated completely and has given much more information than they needed to in order to clear everything up, then we turn that file over to the public, even though we've said there wasn't any action, that was appropriate. That's where I've got a little bit of concern, because if we do want people to fully cooperate with us when we're doing an investigation, but then we tell them we're going to disclose to anybody who asks, once we declare it, there's no merit. I would like, and I know it's a balancing, but I do think, boy, we could really be feeding into a negative, news cycle in a way that really I don't think we would ever want to be engaged in. So, is that something that you've struggled with, and do you have any proposed solutions? I don't, because I'm just thinking about it, but I'd like us to keep thinking about it.
It is something that I struggle with, and it's something that we have been dealing with, because one of my focuses as chief, as everybody knows, is to make everything transparent and fair. I want everybody treated the same way, and I don't want it to matter who sits in this chair, that person does the same things, because the rules are all very clear. And so for me, looking at the rules for the California Public Records Act and seeing what you have to disclose, it goes back to your record retention policy as an agency and as a division. It goes back to what your business practices are, and it goes back to what you put in a working file versus what you put into a file. So these are all things that we've been examining to see what our business practices are and how we apply them, because that's the rules that you follow when you're releasing documents. So we've been looking at this internally as an agency and as a division, and we're trying to make sure that all these rules are written down as to what you keep in the file and what you don't. Subpoena documents we don't give out under public records. So generally, if it's going to be highly sensitive personal information, I advise the investigators to instruct the other side to ask for a subpoena. And in order for the information to be confidential, especially if it's personal bank records and such. There are other mechanisms that we've been using in the past to address this, but this is an ongoing thing that we are trying to get our practices completely transparent, and working with Aaron in order to make sure that we're following the Public Records Act in order to disclose the information that the public should see that support the file, but not putting in things that are beyond the evidence needed to prove the elements or disprove the elements, and making sure that our case management is what it should be in order to best comply and give people the information that they need.
Thanks very much. Thank you.
Any other questions from the commissioners?
I just had one comment. This has been a really kind of informative discussion, and thanks for all the comment letters. One kind of clarification, I think in F2 line, page 8, line 18, there's a reference to the privileged or confidential language. I think we should probably add the reference to private there as well, just for consistency purposes. Otherwise, most of my questions were answered, so thanks.
Okay, great. Public comment on the, sorry.
I promised I would turn it off, but I just have a very quick, I'm sorry. I just a point of clarification, but before I do, I ask that question, I want to say I think that the regulation was really nicely reorganized. I think it's a lot easier to follow. I like the headings. I think the prior regulation was kind of all over the place, and I think this is a much easier to follow regulation. So thank you for that. On the commission initiated complaint, it seems to have eliminated the report or the memo regarding that would contain the reasons why we declined to notify the subject of the complaint. Am I wrong about that? I didn't see it in the
memo
proposed.
to whom?
Hold on, it's in F4. So let me just find
I have a
that.
feeling this falls under one of the categories of not current.
It's probably.
But okay, where is that?
Um, Okay, let me find notice. Notice to complainant.
Is that on page 5,
Yeah,
line 10? Is that the one you're referring to?
it's gone. I'm looking at the new one, so I'm sorry.
If the executive director makes a
Yeah.
determination, he or she shall prepare a memorandum setting forth
Yes,
justification for the
that's the one.
declaration.
And I think that's gone in the proposed regulation. Is that just because it's just not done? It's just not the practice? Is there a particular reason why it's not done?
Well, I've been in enforcement 11 years now, and I cannot recall this report. But when we looked at the reg, we didn't just look at what the current practices were. We looked at what best practices would be. So one of the things that we considered was the due process for the respondents. And one of the commission's roles is to be the neutral arbiter of everything that we do, as well as the legal division and their check and balance of when they do probable cause conferences. So when we looked at this report, as, does this give information that would give questions to the commissioners that would then ask us questions we couldn't answer in order to maybe not strengthen the wall that is between enforcement and the commission, whereas the executive director acts as our check when it comes to complaints. That's why the sworn complaint process has a process where they can appeal to the executive director for reconsideration. So the checks and balances are in place, and obviously the other one is I serve at the pleasure of the commission. So if there's things that come out and it's not the direction the commission wants to go, there's also that check and balance. So it was something that we looked at and we said, is this something that causes more problems, or does it actually give disclosure, or does it enhance due process? And we came out on the side of it doesn't enhance due process, because then it includes the commission at an earlier stage than what they would normally be involved in, and that could be later a case that comes before them. So that was the analysis that went into whether or not to restart the process that was in the regulation or revise it.
Okay, that makes sense to me. But I wonder, does the subject of the complaint then ever get to hear why he or she didn't receive the notice?
Usually the subject of the complaint is contacted later in the process. So they find out, they usually have a very good idea why they weren't notified early on. But we explained that to them as the destruction of records, the witnesses that needed to be contacted before they were contacted. They usually have a very clear understanding why they weren't notified earlier.
Okay, thank you.
Okay. Any other questions from the commissioners? Okay. Public comment?
Good morning, Chair Remke, members of the commission, and especially Commissioner Ardero. Congratulations on your appointment.
Thank you.
My name is Sean Mason. I'm the city attorney for the city of San Mateo and the chair of the League of California City Attorneys Department FPPC committee. And it was our letter that was submitted, and we noted that a couple of the comments that we suggested were adopted by staff. We're happy that the staff found those suggestions helpful. And with respect to the conversation about the balancing, the only item I actually wanted to talk about this morning was the G4 section and our recommendation there. And as a public official myself, and as a lawyer to public officials, I very much appreciate the balancing that the staff is aiming for here in terms of notice and when not to provide notice. And we certainly, from a policy perspective, support the balance that this proposal strikes, and support staff in that proposal. The one confusion that we see about G4 is that, and I'm happy that we read it correctly, that it is a catch-all, that the rules are for sworn complaints and for self-initiated, the enforcement chief may disclose, and G4 is an attempt to provide guidance on the exercise of that discretion when to disclose. And one of them is pretty clear that if it could compromise the investigation, then that's when they do not disclose. And we certainly agree with that and understand the policy behind that exception. The other is where there's some confusion, where it's privileged and confidential. And from our perspective and our understanding is all that information is automatically confidential. It's an investigation, and under our understanding of the 6254F of the Public Records Act, that can be withheld. That information can be withheld. So it is in that sense confidential. It can also be provided. It doesn't have to be withheld. And so to the extent, from our perspective, to the extent that this section is trying to provide guidance as to when to exercise that discretion, we get confused when it says you'll exercise it when it's confidential, because it's all confidential from our understanding. And so that's why we were suggesting that, and we totally understand the concern of staff that there might be reasons other than harming an investigation where we might want to withhold information. We get that. And so we're thinking of a different catch-all to provide guidance to the exercise of that discretion that can be used by the Enforcement Division. And we threw some words together. It basically references a balancing test in the Public Records Act about the public interest in disclosure is outweighed by the interest in non-disclosure.
But if we're obviously already subject to the Public Records Act, why do we have to repeat that standard here when it's already set forth?
Well, you wouldn't need to. You would just take out the privileged and confidential in there. But to me, then you're left with, if you just took out privileged and confidential, those words, then you're left with,
Well, privileged, private, and confidential.
right. So you take out those three words. You take out those three words, then you're left with the only time the chief can withhold the information is when it's going to harm an investigation. And
that's too narrow.
And that's too narrow, and we agree with that. And so we're looking for some direction that gives
I guess
you,
I'm confused why you need this. I don't understand the reasoning.
well, okay, because this section G4 is intended to give direction to the chief as to when they are going to exercise that discretion, right?
Right.
And so, they're giving direction, and they're saying there's two standards that apply. One, harming investigation, and two, it's privileged and confidential and private. And we're saying that as a matter of law, it is privileged and private and confidential already. So it's not really adding anything and not giving a broader definition of and guidance to the enforcement chief as to when they are or are not going to provide the information. If the interest was in simply getting rid of the language, you could get rid of that whole G4 section, and you're left with the Public Records Act.
No, I think the section's good.
I do too.
I'm having trouble I'm still having trouble understanding your concern with it, though. Ms. West, did you want to respond at all?
Sure. I think I'm kind of hearing that Mr. Mason's agreeing with us that we need this section, but saying that maybe the wording is limiting us by not having balancing test or other wording in there. I'm not concerned by the language because running through all of the scenarios that have come up, I've figured out everything fits into the language that is there. I mean, even for instance, when we have to work with the FBI, we have to keep an information confidential and not confirm the existence even of the case. These are things that we use under this test, and we do refer to the balancing test under the Public Records Act, and we use that as an outside body of law that we use to constantly respond to Public Records Act requests. Since we get a dozen every 2 weeks. So it's a constant consideration. So for us, that's why we didn't include it in the language, because it is just so ingrained in part of what we do and the law that we follow. But we're happy with the language as is, but open to suggestion.
Okay.
I mean, do you think it would add if the balancing test is added in addition to the language, at the end of G4? That's another reason?
Sure. I guess what our my problem
necessary.
is, my concern is that you're saying that the enforcement chief can withhold information when it's confidential. That's not giving any direction at all, because all that information is confidential. So you're not giving any direction to the chief as to when to exercise that discretion.
But she's subject to the law, as in all these terms have different meanings: privileged, private, or confidential. As you yourself say, they have legal meaning, and she has to comply with the law under all those meanings. And I guess I find your language too limiting and then confusing, I think, since it is part of the law she is subject to, just like when she claims something is privileged, private, or confidential. So I guess I'm still having trouble, but I think unless there's other questions from the commissioners, Commissioner Wasserman?
If I may, because I think Ms. West may have articulated the same thought, but I just want to clarify again. So what I think I'm hearing is the idea that the language suggested by Mr. Mason is that this public interest in not disclosing information outweighs the interest in disclosing, that word interest would encompass something broader than what is presently there. And then what you had said was, but the way we read confidential, in how we read confidential, we are using that standard which Mr. Mason is referring to. So I just want to make sure I understood what the playing field we're looking at here in terms of our disagreement as to what words mean, and what needs to be in this regulation, and what doesn't need to be because it's understood. And it's interesting that it's apparently not completely understood. If we are presenting one thing and Mr. Mason, who is here quite often with his input, is presenting something else. So it just gives me a moment. It's a moment for me to think about that.
So the information is confidential. I think we are in agreement that the information that we're talking about, complaints, responses to complaints, whether an investigation is going on or not, I think we're in agreement that that information is confidential.
It's not necessarily
Right, that's the
confidential.
problem.
So when we confirm that an investigation is occurring, we don't confirm an investigation is occurring when we've done the balancing test to where we can say under California Public Records Act, we can't provide any records because the balancing test says that the interest in keeping these records confidential as opposed to releasing them is met. And so every case that is an ongoing case is an application of the rules on what we are required to release as an agency. So that's why for me, I think what I'm trying to explain is that is the overarching rule that we follow every day, and not just when deciding what cases to confirm, but also what records to release out of those cases. So it's overarching and it applies to the entire regulation.
Right.
And so that's why for me, it's just a body of law that we follow that I have direction from. So
Which
that's
leads
what
to
this
your
gives me.
determination of whether or not it is confidential,
Exactly.
and thus why the regulation is
defines the
drafted in this
term
way.
for me.
But, and I guess our understanding is
Okay.
different because there are two different exceptions in the Records Act. There's 6255, which contains the balancing test. There's 6254F, which says records of investigations are confidential. You do not have to provide that information. You may choose to, but you do not have to. And so there are two different provisions here.
So I'm still trying to understand your concern. Is it that you think that this provision as drafted now with the word confidential, private, or privileged, that the enforcement division will not apply the required law, including when appropriate, the balancing test?
No, I'm not concerned about that happening.
But that's, and I'm still, then, so
Uh,
we
uh,
all agree that these words are things that are taken into consideration, whether it's privileged, private, or confidential. And of course, the overarching principle and law of the Public Records Act of a balancing test. So I guess what are we missing here?
There is information that is confidential and need not be provided. You may choose to provide it, right? The policy of the agency may be to as the policy of the agency was in the past, that whenever there's an investigation of a complaint, we're going to make all those records transparent. You can do that. It's not illegal to do that, right? But the policy that's being articulated here is that there are going to be circumstances where we don't want to do that. And we're defining those circumstances. That's what G4 is doing. It's defining the circumstances when we're choosing not to make the information public, right? And so we're saying on one hand, it's when it could hamper an investigation. Totally agree with that. It makes sense. On the other hand, we're not going to make it public if it's confidential. It's all confidential.
I think
And
there's
so
a,
we're not saying anything.
We need to move on. This
We're not
is
adding
like
anything by using
I
those
feel like we're
terms.
going round and round here.
I think we have a
that's fine.
clarifying point from the staff perspective. I think we have to look at whether we're covered by 6254F, which is the law enforcement investigations
Right.
exception. And Galena and Hyla could speak further to it. But my understanding is that that only applies to specified law enforcement agencies.
Right.
And so that we're not absolutely covered by 6254F, which is why we have to use 6255, which is the balancing test. And I think that's why Galena is trying to articulate that under in that the subdivision we're talking about. Not the entirety of the file is not necessarily confidential under the Public Records Act. So what she's trying to do in any given case is determine with particularity to the existence of the complaint or particular records, what would be then exempt under 6255.
Okay, thank you for that clarification. Do you have other comments,
No, that was it.
Mr. Mason?
No, that's
Okay,
it. Thank you very much.
thank you. Is there any other public comment on this regulation?
Madam Chair and Commissioner, good morning. Brian Hildreth from Bell, McAndrews, and Hilltech. I'm the co-author of a letter that was submitted on Monday. Should be part of your packet. I figured out about 45 minutes ago as I was walking over here why my senior partner said, "Hey, we should both sign this letter." So I'm here. But we wanted to express our appreciation. It looks like some of the changes that we were asking for were in fact included in there. So appreciative very much of the staff, the 4 attorneys you see sitting in front of you, very helpful. Something that was not in our letter, but that was discussed and I think is an important component of acknowledging when a complaint has come in is the language, the follow-up language that we haven't made a decision what to do yet. That gets printed virtually every time, I think, in an article. I think it tends to down the sparks that fly off of a complaint when maybe competing candidates are using the complaint process as press releases. So I think that's an important component, and it looks like it's going to continue. So appreciate that as well. Thank you.
Thank you. And thank you for your early comments showing up at the IP meeting. Okay, any other public comment on this regulation? Is there a motion?
I move approval of the staff proposed measure
With the amendments,
with the amendments, 1118.
I second.
Commissioner Darrow,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
yes.
This motion passes.
Thank you. Thank you, everyone, for your time and thoughts on that one. Okay, item 15 is adoption of the 2015-16 Form 700. 75. Did I say 15? I was jumping to 2015-16. All right, thank you. Item 7.
Good morning. My name is Trish Mayer. I am the Assistant Division Chief in the Technical Assistance Division. And this morning I have for your approval the annual update to the Form 700 and the related documents. As my memo pointed out, the main changes include updating the dates. As you know, the form covers a different calendar year. I've also included information on the destination of a trip, which was recently added as a result of legislation. We've done some clarifying questions and answers and updated the cover page as a result of comments from city clerks and county clerks who use this form all the time to help relieve some problems with filers forgetting to mark some boxes. So I ask for your approval.
Okay, do the commissioners have any questions? Any public comment on item 75? Okay, is there a motion?
I move approval of the Form 700 for 2015.
Second.
Commissioner Darrow,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Thank you. And then item 76.
So the next item for approval is the agency's campaign manual 1 for state candidates. The biggest change to the manual is to make it consistent with the style and format of the other recently updated manuals. We incorporated changes as a result of legislation and regulatory action. We also included some public comments that we received during the public comment period held in September. And Commissioner Wynn, I made a note on your suggestion. We also have to update going forward all of the other manuals to incorporate the campaign changes, and I can keep that the termination comment in mind going forward on those. I ask for your approval.
Go ahead, Commissioner Wynn.
Thanks very much. I thought the manual was really good and very complete. So thank you for that. On page 14, and I don't have it in front of me, but I did make a note, lifting the voluntary expenditure limit. So if a self-financed candidate blows past the limit, then that lifts the limit for every other candidate?
Correct,
Okay.
yes.
And to what level? Does it just blow the top off and you can?
There's no level after that.
Thank you. I wasn't aware of that until I read the manual, so thank you for that.
Any other questions or comments on the manual? Is there any public comment on the manual item 76? Okay, I do actually have a comment. Well, I have two things actually. The first one, I know we're going to ultimately have a motion. I believe we're going to have a motion. And I just find this slightly odd, and I don't really know what the motion means. The motion means what? That this is a manual of the FPPC? Does it mean that everything in the manual is read and approved by each of us? I just think approving manuals like this is a weird process. And I know there's some history to it, but it doesn't really make sense to me because it is a resource guide. It is a secondary resource guide to help the public. So why, as a commission, do we need to approve it? I mean, go ahead. That's my. I'm not opposed to doing it. I just think it's odd, and I don't really understand the meaning behind it.
Yeah, I don't either, but maybe we should put this on as an information item rather than a formal approval.
Am I correct that currently the regulations require us to approve
Well,
it?
that's right. Currently, the approval is required like changes to a form. But we're going to work through it as, we're going to attempt with the new manuals. Linda worked a lot on this manual 1. So all the manuals are up to date now. So we want to keep updating them quicker, chapter by chapter and things. So either they'll just be coming before you more, or we could modify parts of that. If it's a small revision, it doesn't need approval, but currently the reg does require approval.
But what does that
for the
approval
manuals.
mean? And I guess, or can we change the reg, or we clarify in the reg or at the motion what we're approving? Because again, I don't understand. I know we've done several of these now, and I've kind of done it as, yes, this is the manual. Yes, this is a good job, but I'm not approving every statement in the manual because I didn't go through it that clearly, and it would take me about 1.5 years to do so.
That's true. It's just showing commission adoption and showing and having we have the public notice period so that there's public comment on the materials. We do get people reading through the whole manual and commenting.
No, I read through it all. I'm saying though, to check the law on each statement
also.
and each question and that's what staff has done, and that's why we're it's a great piece of work. It's very helpful. I get it. I want public comment on it. It's fine to bring it before us, I think, as this is something that's going on and this is what we're putting out there. Again, and maybe the other commissioners feel differently or understand it differently. I don't understand what a motion to approve the manual means. And I'll leave it at that. But Erin, did you have something to add?
Yes, I do. No, I just wanted to thank Linda Cassidy, who's obviously now retired, but also Trish and all of their staff. They worked incredibly diligently over several years to get these manuals updated. They had become outdated sort of during the furlough period when the commission was really understaffed and overworked. And so we worked really hard. We think these are incredibly valuable educational tools. And just kind of in response, there was a comment letter from Common Cause sent in on the manual. And I just wanted to highlight that the manuals are only but one tool in the toolkit of FPPC educational materials. We launched a local candidate toolkit, which the chair mentioned briefly earlier this year, which was intended to really try to get to those types of candidates that are first-time office holders or first-time candidates, maybe more at a local level, small races. We were proud to work on Assemblyman Gordon's bill this year, which changed some of the triggering thresholds for candidates at the very local, small levels. And so we're always looking for ways to better educate those types of people to encourage participation in the political process. And for another just example is we have tons of different charts on our website for all of the ad disclaimer requirements. All of the contribution limit charts are very helpful since I can never remember, since they're indexed for inflation. And then another thing Trish and her staff work very diligently on is producing campaign filing schedules that are specific to elections. So you can actually go on, she informed me this morning, we've produced about 65 a year. 40 of them are posted on our website because they're specific to specific kinds of committees in a specific election. But we also provide that service to local elections officials upon request. So we've done about 25 this year for specific local elections. And as we all know, we're working diligently to get our new website up, and we hope that that will be even further making clear and available all of these really important resources that we produce. So I just wanted to highlight all of those efforts, and there's many others as well. Trish and her staff go out and do tons of presentations. We have webinars. We have already started our process of looking at 2016, since it is an election year, and making our plan for those types of outreach and training. And I know the webinar program was really successful in 2014 because they did a very good job of trying to access people so for example, we have them towards the end of the day at 4 or 5 o'clock because we understand most local candidates are not full-time public officials. They have day jobs. And so we've tried to make some of those just kind of tweaks to our program so we can really get to those people and reach them and provide the information that needs to get out there.
Thank you. Yeah, and I would just concur in thanking Trish for all the work she's done and stepping up with Linda's departure and working double the job. Thank you a lot. Okay. Did I ask for public comment already? Yes. Is there any other comment other than my comment? I guess I've stifled the But I'll leave that, my thought, at if, Hyla, you can look at the regulation and perhaps even propose some suggestions or help me understand the meaning behind this. But with that, is there a motion?
I just have a comment. I agree. I agree. I am particularly even in more agreement now that I've heard how many of these there are. And I think it's wonderful, and I think it's great, and I think the more information we get out there, the better it is for all the stakeholders. But this is a lot, and if we need to do it, we'll do it. But I agree. I mean, if the act requires us as a commission to do it, it's one thing because we don't get to change that. but we do get to work on the regulations, and if that's something that we came up with when there were 3 tiny little guidances like this, that's fine. But now that we are so prolific, and it's a great thing that we are, I agree with Chair Remke that we should question this.
I think that if we're going to be contemplating that, we should address that at a later date, because I have some thoughts on that may not be in accordance, but I think this isn't something anyone has really fleshed out other than a reasonable sort of, why are we doing this question, which I think is always a reasonable question to ask, though.
Right. It would be in a regulatory change because there is a regulation that specifies the commission has to approve them. And it's a concern about underground regulations.
Right.
The manual has examples and it has information. We don't think it has underground regulations, but that's the balancing concern.
Right. Because that's a concern in other entities and other agencies, the federal and the state, IRS. Well, I won't name any others.
Other agencies, many other agencies.
And I understand that. I understand that because I've litigated that issue. So I hear exactly what you're saying, but I also agree that we need to flesh this out because it is a regulatory change. So.
Mm-hmm. Right. So no change now.
Is there a motion?
Yeah, I move.
Second.
Commissioner Darrow?
I will say, sure. Yes.
Commissioner Kasher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn? Chair Remke?
Yes.
This motion passes.
Thank you.
Thank you, Trish. Okay, and then item 77, the executive staff reports. Do the commissioners have any questions or comments on any of the reports? If not, they will be submitted. Are there any particular questions, comments? Okay, those are submitted. Unless there are any more questions or comments from the commissioners, I would move to adjourn the meeting.
Second?
Commissioner Darrow?
Yes.
Commissioner Kasher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Rumke?
Yes.
This motion passes.
Thank you, everyone.